Today we're going over the federal rules of evidence. In particular, I'm going to show you how to master FRE 403. That way you'll be all set for your next trial or mock trial. Truthfully, it doesn't matter as long as you're killing it in the courtroom. And that begins right now. Stay tuned. Welcome to Law Venture. My name is Jarrett Stone. Since you're watching a video about 403 objections, then I highly recommend that you download this cheat sheet with the 21 most common trial objections, all boiled down to a single cheat sheet. Super helpful for game day. It also super helpful because it has the 21 ways to make these objections. It has the 21 breakdowns of when to make these objections. And it also has the 21 ways to respond if somebody makes these objections to you. It's super helpful and super free. If you want to get it for free, then go ahead and look in the description. I have a link, click it. It'll take you to my website, type in your email address, and that way it'll get sent directly to you. I also recommend that you watch this video if you haven't already, that it's sliding. I'm getting very interactive over here. It's the top 10 trial objections that you're going to be making in front of the jury. You want to have these down pat because you're in front of the jury. The show's on, so you need to be on your toes. Make sure you watch it, make sure you understand it. If you have any questions about that, then let me know in the comments below. Okay, so let's go ahead and dive into FRE 403. But before we get into the nitty-gritty and the examples, I think we first need to talk about the concept of 403. You always want to keep in mind that evidence can be improper for multiple reasons. And if that's the case, you want to make multiple objections to keep it out. And whenever you do that, you basically are going to have this tiered level of objections. That way, if the judge overrules the first on the top level, he moves on to the second. It's a little bit like Inception, where you just keep going deeper and deeper and deeper. Now let's make this concept maybe a little bit more concrete. Let's say opposing counsel is trying to admit a certain document. Well, you may want to make the objection that it's hearsay, but let's say you look at it and you also determine this isn't relevant, so you make the objection relevance. But at the bottom of this tiered stacked Inception level of objections, you are going to most likely want to make this catch-all objection. That is rule 403, because if the judge determines that it's not hearsay or an exception applies, overrules that one, determines that it's relevant, overrules your second objection, then you're gonna have to use 403 as the last stand. And this is an important concept to understand. Rule 403 is designed to keep evidence out that just simply isn't useful. Yeah, it may be probative, yeah, it may be relevant, but if it does more harm than good, that's when 403 comes in. Now keep in mind that the more harm factor doesn't mean that it's prohibited by 403 simply because it weakens your case. We live in an adversarial system. Opposing counsel is allowed to weaken your case and to strengthen their own case. But 403 in particular prohibits certain types of evidence that weaken your case for the wrong reasons. So the question is, what are those particular reasons? Well, to find that answer out, we have to look at the language written in 403. So let's do that. Rule 403 states that the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. That's a little bit of a wordy rule, and truthfully, there are a lot of examples. Fortunately, we can look at the title and we can see that these examples fall under three main categories. We have prejudice, we have confusion, and we have waste of time. Now I want to touch on all three of these, that way you know exactly when you need to be making the 403 objection. But let's start with waste of time. With the 403 objection for waste of time, your job is to appeal to the judge's sense of judicial economy. Judges are all about saving time. They want to keep the trial as short as possible. And it's a little bit easier on the jury if they don't have to pay attention for nearly as long. So my recommendation is to explain to the judge during your objection and wait for it to be kind of egregious. Wait for it to be an obvious sense of a waste of time to stand up and object and explain to the judge that opposing counsel's exhibits, testimony that they're trying to introduce, or just arguments have very little, if zero, probative value, and that's substantially outweighed by the fact that it's cumulative, or that it's not allowing this case to proceed forward and that we're getting hung up on this particular issue. Judges typically know what you mean. And notice I didn't say that this particular fact or this particular piece of evidence is a waste of this court's time. that's kind of harsh. So use your judgment and take in the environment on whether or not you want to come off that harsh by saying opposing counsel is wasting this court's time. Typically, you want the judge to reach that determination on their own. And if it is pretty obvious, the judge isn't going to need much of an argument. The judge is going to know exactly what you're trying to say and go ahead and sustain that, turn to opposing counsel and tell them to move along. The jury is going to be super happy because they're probably bored out of their minds if they're getting stuck on the same fact over and over again. Now, you typically want to make this objection when opposing counsel is maybe getting hung up on the same fact that may have been stipulated to, or may not be in dispute, or may have been proven earlier, or if opposing counsel is just flooding the court with the same exhibit or similar exhibits that all prove the same exact thing. At that point in time, you may want to make things easier for everyone by making that simple objection and moving the case along. Speaking of moving along, let's go ahead and move on to the confusion aspect of 403. The 403 objection under the confusion category can be a ton of fun, but proceed with caution. You first need to determine whether or not your judge will allow for speaking objections. If he doesn't allow speaking objections, then you need to approach the bench, you need to make the objection that opposing counsel is confusing the issues or misleading the jury, or the witness is doing that, and then ask for the jury to be excused, and then outside the presence of the jury, make your argument and your justification. And if you can do that successfully, then at the very least, at least the judge will start being more critical of opposing counsel or that particular witness. But here's where things get fun. If the judge will allow for speaking objections, or you get a read that the judge won't be mad if you explain how opposing counsel is misleading the jury or how opposing counsel is confusing the issues, then go ahead and provide that justification, provide that argument that shows to the jury indirectly by making the argument to the judge that opposing counsel or the witness is basically distorting the facts and distorting the truth, and then provide what the facts should be and provide what the truth actually is. And at that point in time, you kind of have a mini closing argument going on, and then wait for the judge to make a ruling and then sit back down. But you were able to accomplish what you wanted to accomplish, which was providing your argument. Now, whenever you make this objection, again, you need to be technical to where you explain to the judge how opposing counsel's point, argument, whatever, has little to no probative value, and that's substantially outweighed by the fact that opposing counsel is misleading the jury because X, Y, and Z, then justify it. Or how opposing counsel is confusing the issues, and the real issues are A, B, and C. And then once you make that justification, then show to the jury how opposing counsel or the witness is distorting the facts, distorting the issues. And that can be super, super powerful. And it's a great way to go on the offensive. But if we start talking about defensive, then we need to go ahead and move on to prejudicial, because this one is super, super important and definitely not one that you want to make in front of the jury. So pay attention. The prejudicial category gets to the heart of 403. You can tell by looking at the commentary underneath 403, because it says that it is intended to make sure the jury reaches a verdict from a place of logic, not from emotion. And so it's designed to prohibit evidence that's going to spark strong emotion from the jury. That emotion may either be anger or sympathy, but the intended purpose is to make sure that those emotions do not blind the jury from reaching a verdict and a decision from a place of logic. 403 wants the jury to reach a calculated decision, not an emotional decision. And so the test at this point shouldn't be a surprise. It's whether or not the probative value is substantially outweighed by the unfairly prejudicial effect. Now notice that the phrase unfairly is written into 403. This gets into the whole more harm than good, and that the more harm doesn't mean that it just hurts your case, but that it really doesn't have anything to do with the case other than the fact that it's going to make your client look bad, or it's going to bring a strong emotion from the jury in favor of the opposing side. And here's an example that makes that a little bit more concrete. Let's say that you're representing a defendant in the car wreck case, and the plaintiff is alleging that your client's at fault because he was texting while driving and he was distracted and he's the one who caused the wreck. Let's also say that you're in trial and opposing counsel tries to introduce a particular piece of evidence, which is a screenshot of your client's text messages. And with this particular screenshot, it has the timestamp that shows your client was sending and receiving text messages minutes before the collision. And at the very top of this screenshot, instead of a name like John Smith, it just says drug dealer. So the question, is this particular piece of evidence going to basically be rejected or denied due to Rule 403? Now, when it comes to the timestamps, that's gonna hurt your case. But that's not gonna hurt your case for the wrong reasons, because the timestamps actually prove or show that your client was most likely at fault. It's not good. It's not a good case. You don't want to have that case. But the name in particular at the top, it just says drug dealer. That particular aspect, I would argue, is extremely unfairly prejudicial, because the fact that the person who was receiving and was also sending text messages is a drug dealer has no bearing on the case and doesn't go towards actually proving that your client's at fault or was texting. The timestamps prove that, not the actual name. The risk here is that if the jury were to find out that your client, abuses drugs or whatever, and was texting a drug dealer, then the jury may be really angry about that, or the jury may actually be more critical or hypercritical with your client. And that's coming from a place of emotion. So at that point in time, you want to make the argument to the judge that there's very little probative value in having the name there, and that should most likely be redacted, and argue that it's substantially outweighed by the unfairly prejudicial effect of having the drug dealer in there. Now, most likely you wouldn't be able to get the entire document, denied or not introduced into evidence. You may want to make the objection of hearsay, but truthfully, it probably is going to pass the hearsay muster. But overall, that particular piece of evidence or that particular fact involving the drug dealer, that's highly, highly prejudicial. And that is the intended purpose of having Rule 403. I hope that made sense. I kind of, went off a little bit, but we're getting back to the point now. So if that didn't make sense, be sure to leave that in the comments. If you have any questions about anything, again, leave those in the comments. And if at this point you're still watching, don't forget to give this video a thumbs up. And if you haven't subscribed yet, no pressure, but it's over there. All right, I'll see y'all in the next video.